This is a very exciting day. In fact, it talks about real estate taxation and train law. So, good morning, Filipino homes. Welcome to another online learning brought to you by our new program, FIRE. Okay, so FIRE stands for Filipino Homes Institute of Real Estate. And today, since it's a very exciting topic, real estate taxation and train law, I would like to introduce to you our distinguished speaker. He lives to share his knowledge to other people. A talkative, hilarious guy. He started his teaching career as one of the youngest professors in the two big universities in northern Mindanao. He became a real estate broker, appraiser, and a lawyer during his 18th stint in a government corporation that deals with real estate. He was credited by the legendary Rev Cebu president, Jose Pacquiao, as the major contributor in the production of Rev Cebu Top-Notchers in the August 2015 Real Estate Appraisers examination, and 86% passing percentage during the February 2016 Real Estate Brokers exam. A national speaker, reviewer of various examinations, and a trial lawyer topped by his associates on land cases and disputes. Mesdames et messieurs, ladies and gentlemen, please help me welcome Attorney Walfredo Lumunsod Alcantara. Good morning.
Good morning, Boston.
Yeah, so it's exciting again to have this topic. In fact, a lot of people last night, we ended about mga 12 midnight having a meeting siya. Boss, I'm excited for Attorney Wally. You are very slang now in talking. You're like an American. Okay, so take it away, Attorney Wally.
Yes, Boston. Thank you again for having me. Good morning, real estate. Two things that you cannot escape in life. One is death, and the second one, taxes. Now, I want you to bear in mind that a state, the country, every time the country needs money, actually it is just like you are a member of an organization or a fraternity. So you need to have funds in order to have your projects accomplished. So here, the first thing, it's in the government. It's also in the government. The government will always think of taxes. So in order to raise revenues, that's the only way to increase the tax. Now, we are so happy that during this time, administration of President Duterte, the tax laws are simplified. Now, compared to the previous administrations, the tax provisions are very, very difficult to decipher, to understand. Sometimes there are phrases like, for example, uh, provided further, provided finally. So, in other words, there is a problem in the interpretation. But now it's a good thing that the tax laws are simplified. Okay. Important provision of RA9646, or the RESA. Section 32 states that the divisions or departments of partnerships and corporations engaged in marketing or selling any real estate development project in the regular course of business must be headed by a full-time registered licensed real estate brokers. Now, well, full-time, it means that he should be in the office as a general rule.
Yeah.
Now, branch offices of real estate brokers, appraisers, or consultants must be manned by a duly licensed real estate broker, appraiser, or consultant, as the case may be. Now, subject to the provisions of the labor code, a corporation or a partnership, a corporation that may include also a real estate developer, may hire the services of registered and licensed real estate brokers, appraisers, or consultants on commission basis to perform real estate services, and the latter shall be deemed independent contractors and not employees of the of such corporations or real estate developers. Now, there is now a line now, a demarcation line, because of the section 32 of the RESA. There is a demarcation line because, as mentioned here, this provision implies existence of employer-employee relationship. So, as mentioned a while ago, subject to the provisions of the labor code. Like, for example, if you are a full-time, the broker is a full-time worker in a company, in a real estate uh, developer of the real estate developer. So in other words, like for example, he serves for 8 to 10 hours a day, and probably that real estate broker was terminated from his job. Now, these are the requirements of employer-employee relationship. So there is a possibility that the real estate broker who served for 8 to 10 hours a day could file a case for illegal dismissal before the National Labor Relations Commission, and the basis of the NLRC would be based on the requirements, if the 4 requirements are present. So, like for example, number 1, who selected that real estate broker? Who engaged the services? Like if you are going to interview that person, interview that broker, then he was able to comply the first requirement. The second one, who paid his salary, his wages? So if it's the company who paid the wages, then he was able to comply the second one. And who has the power to dismiss that person? Is it the real estate developer, the company? And the fourth one is the power to control the employee's conduct. And one of the evidence here to determine is the power of control, which is the most important element in the 4 requirements. Like for example, you are going to allow him to use the biometrics in entering the company premises. He enters at 9 o'clock, leaves at 6 o'clock, because it was an instruction of the management. Ladies and gentlemen, he has already complied with the 4 requisites. The concept of independent contractor does not apply anymore. So, in other words, the treatment now is very much different. If, for example, you are an independent contractor or you are an employee, the treatment, so the tax application would also be different. Okay. Now, this is one of the big problems if the NLRC would declare that there is an employer-employee relationship, the person is already considered a permanent employee, Just imagine now, before the maternity leave was only 60 days, but now it has already extended to 105 days. And just imagine, he must receive full pay, and employers, because she is a member of the SSS, but there is a directive coming from the BIR RMC number 10529 2019, issued on 9 October 2019. Employers from private sector shall be responsible for the payment of salary differential between the actual cash benefits received from SSS by the covered female workers and their average weekly or regular wages for the duration of the maternity leave. And the salary differential is considered exempt from taxes. Okay, so it's really a big problem. Now, under this category, real estate salespersons may fall under this category. So if also the real estate salesperson was also required to work 9 to 6 o'clock, that could be a reason that he or she may be considered as an employee of the real estate developer or real estate company. So the most important is you have these 4 requirements earlier mentioned. Okay, so as a general rule, actually prior to this train law, actually before, so if you work in a company like a real estate developer, the application for a tax identification number, or the submission of the BIR requirements, like the birth certificate, valid ID, and so on and so forth, that's the job of the company that you're working with. So all you have to do is the preparation of your income tax return. As a general rule, you just sign these documents, and they have this liaison officer who will just go to the BIR regional district office and submit these documents. That's what happened before. Now, like for example, there is a form that would be filled up. I think that's our BIR form 1902, where you place your name, your address, your profession, and so on and so forth. But because when you applied for a job in that real estate company, what happened is that you have this resume, then you have your, when you were already an employee of that company, you have your 201 file, so they could fill up the BIR form. So all you have to do is just to sign. And when it comes to what you call, this applies, ladies and gentlemen, to all, especially in government agencies, and this applies also to private agencies. So as long as you are an employee, that's the job of the HR in your real estate company. Okay. Now, I want to inform you that when you before signing this income tax return that would be filed every on or before April 15 of the following year. So make sure that the amount paid in the gross income in the community tax certificate is equal to the gross income of your income tax return. So sometimes what happens is that before you sign it, there is what you call a portion there. What is the amount that you paid when you secured your community tax certificate, or that is what you call cedula. Now, some people would secure tax cedula and they will get just pay 50 pesos. But the income in the income tax return is more than that. So just be honest. If you earn if you earn for example it's 300,000 pesos, and the basic tax there under Republic Act 76 the 7160 or the local government code is that per 1,000 is equivalent to 1 peso. So just be honest that if your income is 400,000, this then you when you secure your community tax certificate, just state that it's 400,000. Okay, not 50 pesos. Okay, but now there is a revenue regulation number 1 2020 issued on January 9 2020, section 8 of revenue number 11 2018, which lays down the procedure for filing of application for registration of individuals earning compensation income. Okay? BIR Form 9 is amended by directing all employers to require only employees with no existing TIN numbers to accomplish in triplicate. So a while ago, I was mentioning that it should be the role of the private, the developer, if you're already an employee. But now you have it's a regulation coming from the BIR that if you don't have a TIN, you have to accomplish that one. Okay. Now, this is a problem if you are considered also a independent contractor. So if you are an independent contractor, it means that you have to work this one on your own. Now, like for example, an application for a TIN. So when you go to the BIR, you apply for a TIN, then there are requirements, just like what I told you, the birth certificate, valid ID, government issued valid ID, and also a sworn declaration or an affidavit. So now, if you have a business because you put up a realty business, okay, a realty firm, then you have to include a business permit. You get a business permit first before going to the BIR. Now, once you have that one, actually you need to attend a seminar. And it is actually an opportunity for you because when you attend a seminar, which is usually 2 hours, the BIR personnel will discuss your rights and obligations as a taxpayer. So you can ask anything under the sun there. You can ask anything about taxes. Okay. Now you are also being taught how to prepare your income tax return. Now, and certification issued that you attended a seminar, then for application for registration, this is every year, okay, you pay 500 pesos. Then you need a ledger. Then once you have that one, then they ask for a receipt sticker that's color red and white, then authority to print official receipts. So in official receipts, sometimes this would take time because there are a lot of things that would be printed in the printing press. So sometimes all you have to do is to ask, can you print usually they print it of 100 stubs. So you just ask if possible, can you print only first 10, only 10, what do you call this on 10 stubs, so that you can already issue receipts when you have already sales, example like that. Okay. So that's it. Now, so that would be used for gross sales. Now, quarterly. Now, the basis there of your quarterly income would be like, so January, February, March, then that would be filed and paid on on the following month. So how much is your income for January? How much your income for February? How much is your income for March? So that there is a schedule for that, when to file it. Okay. So that could also be, everything should drive now, because there are 4 quarters in one year that will be used in your income tax return. By the way, you are only allowed one teen for the rest of your life, even if you are a working at the same time, you are a at the same time you have a business. You are only allowed one teen for the rest of your life, and that is what we call, I could say, that even in the worst of times, there is still forever. So a teen is a forever number of yours. Now, um, before, actually, when this RESA took effect, the contribution was recognized by the BIR. So before, brokers and agents, the tax before, the Revenue Regulation 10 2013, before, okay, this is before. Now, what happened was that the tax before, it states here, individuals on the gross professional promotional talent fees, 15% if the gross for the current year exceeds 720,000. That was before. And 10% if it does not exceed 20,000. The most important before was that um you must you must submit before the BIR a sworn statement that your income did not reach or did not exceed 720,000. If you don't have that affidavit, then the application is 15% gross. Uh, gross. So the basis there is the receipts that you issued, that was printed. Okay. Now, this applies to those who failed in the examination and did not take the licensure examination, for brokers, appraisers, and consultants. Then it is 10%. Again, that was before. I was just explaining that the BIR recognized the major contribution of real estate practitioners. Now, here, the real estate agent, so there are requirements in order for one person to be considered as a real estate salesperson, and you took that up when you took RA 9646. I think that's Dr. Ong at the time. However, in reality, I have to be honest that there are some real estate developers which are not actually strict on the requirements, because on their part, the most important is sales. That's it. The most important is, but there are requirements, of course. That the number one requirement, which is also very, very difficult to comply with, is that you need at least 72 units in college. That is very, difficult. Some of the Filipinos do not have this requirement. Anyway, so I just mentioned about the reality, what's really happening in the field. So once you are an agent, it was mentioned in RA 9646 that an agent is under the real estate broker. So the first step, that if you want to be a real estate agent, you approach first a licensed real estate broker, and be affiliated with this real estate broker, because the real estate broker has a maximum of 20 20 salespersons. So it is now the job of the real estate broker to train you and to let you attend seminars and so on and so forth. That's for to enhance your knowledge about real estate uh, brokerage and transactions. Now, this is a computation. This is only a simple computation. What you call this? Commission, which is also the basis in the computation of your income. Now, assuming there is a unit that is being sold, and the price is 1 million. Now, the miscellaneous, usually the developers charge there is 12%. Okay. Now, so you deduct 100. You deduct here 120. You deduct 120,000. So you 1 million now minus 120,000. You have a net total contract price of 880. Okay. Then, if the commission here is 3%, then you get 26,400, but that is still gross. Okay, that is still gross. Now, times 8%. Why is it 8%? Probably you could remember what I told you. Sir, you said that if it is less, the income is 720 below, it's 10%. Why? It's 8, because that was before. But now we have the train law. Now, and the train law, it states that you have actually you have an option. If you are, like, for example, practicing your profession or self-employed, because you are considered what I mentioned a while ago in section 32 of RA8624, independent contractor. Okay, so you have the option 8%. So 8% of 26,400 is 2,112. So if you deduct this 26,400 minus 2,112, you have 24,288 per unit. However, this amount, you cannot claim that amount, the whole amount, because if it is, for example, if it's installment, then you will be entitled only for the a portion of that until it would be fully paid. So this is very very important. So the receipt that you will be issuing also will be also for that portion. Now, again, I have to be honest that in reality, what is really happening in the field is that they are not, real estate developers are not, there are some that are not strict on requirements, because if considered as a real estate agent, you have to attend CPD seminar, you are affiliated with a broker, attend CPD seminar, then again 72 units, then that's it. You sell the units of this projects that your real estate broker is affiliated with. So there are requirements, of course. I mentioned that's difference in actual practice. Okay. Now, there is an issuance of the Department of Finance here, RMO number 23, 2018, dated 21 May, to avail of 8% income tax rate option for individuals earning from self-employment and or practice of profession. So in other words, in the train law that would be discussed also after this presentation, there is what you call a graduated scale of the income. So in graduated scale of the income, the first 250 100,000 would be exempt. There would be 0% there. But so it's not actually automatic that if you are what you call a self-employed, or you practice your profession, it's not automatic that it is 8%. You have to choose it. You have the choice. You have the choice. Okay. Now, that is his options. Either you choose the graduated income tax rate. That's what I told you, or the 8% in excess of 250,000. In excess of 250,000. Now, the following criteria must be satisfied by the in order to qualify to avail of the 8% income tax rate option. You must be self-employed, practice your profession, the gross sales, the gross receipts do not exceed 3 million. Why? Because the threshold now of the train law is 3 million. Before it's 3,199,000. But now it's 3 million. Okay? So the taxpayer is registered and subject to percentage tax or exempt from VAT, and the taxpayer must signify his intention to elect 8% income tax by tax rate by filing any of the following. For the new business registrant, upon registration using BIR Form 1901, or on the first initial quarter return of the taxable after the commencement of the new business or the practice of profession. So actually, this is a lengthy directive. Now, also the most important is that even old taxpayers, this is not only for what I did not include it in the slides anymore. This is for new. Like for example, you can still avail of this one, even if you're not a new registrant. Now, if you are very busy, like for example, you're very, very busy. My advice to you is you hire an accountant. Well, many would say that they will just hire a bookkeeper and pay a person, pay that bookkeeper the amount of it's just like every time a return would be filed in the BIR, and he will just the person will just pay the bookkeeper. For me, I do not recommend that. Why? You will, if there is an accountant, of course, the payment, it is a monthly payment that you're going to pay. Sometimes they ask for 1,200 a month or 1,500 a month. So actually, it would depend on the agreement between you and the accountant. But the most important there is you just inform you just text the accountant that my income for January, February, and March are the following: 1, 2, 3. Then he does all the computation. And the beauty now is that there is already a software with the BIR, because we are already in the new normal. So there is now a software where you can just encode the income, and it's the software now that will compute everything. So, but anyway, my advice is that if you are not very, very busy, hire an accountant. Based on my experience, and based on the experience of other people that I asked, there are more advantages than disadvantages. Now, always remember this one. Like for example, at the end, like for example, you will be paying your income tax. You will be filing your income tax return on the following year, on or before April 15 on the following year. well, you can still do it on your own. You can still go to the BIR. Then there are still BIR personnel who will, who will assist you. Okay, after filing all this, they are in possession of your quarterly returns for quarterly returns. Then they will assist you. You can still do it. But the most, based on my experience, the most advantage here, when you have your accountant, you can ask your accountant for a financial statement. Okay, and this financial statement would be, they need that one. You need that one when you go to when you approach a bank and you borrow money, and that's very, very important. That's especially banks, especially, like, for example, banks that do not require collaterals. So they need documentary requirements. They need documentary requirements. And, like, for example, a financial statement is because this is being done by the certified public accountants, licensed people, then it is a highly respected and given greater weight by the bank personnel. So very, very important. Okay. Now, my advice to you is this: visit this website, bir.gov.ph. If you just browse everything there, you would be able to, you would be encouraged to study and know about taxes. Because here in the BIR, you just click the organization, the history. What are the BIR rulings? So you start from 2020, 2019, 2018, 20. All you have to do is read, and that's what, if you were present last Friday, I made mention that do not be content of what you have now. All you have to what you're going to do is you study, you read. That's it. So if you read all this, what is stated there in bir.gov.ph, you know what will happen? You can click donors tax. How much? When will it be? The deadline. Then capital gains tax. Everything is there. Again, this is only to guide you. www.bir.gov.ph. Okay. Now we are going to study about the train law. This is from the Department of Finance. Okay. The BIR is under the Department of Finance. The Bureau of Customs is under the Department of Finance. So this is actually a summary of the train law. That tax changes you need to know. Now, okay, this is the preface, table of contents. Okay, take a look at this personal income tax. So the new tax is here. So this is the presentation here is so easy to understand, but I'm not going to discuss about in detail the old tax schedule and the new tax schedule, because we don't have time for that anymore. But you can study the one at home. Okay, so you have it here, the new tax schedule. If you could see it here, it's the first 250,000. Okay, 0 tax rate. So you could see it. There. You could see it everything. So it's easy to understand. So you can also see it here, the for self-employed and professionals. At the bottom, you can see it, which is, of course, self-explanatory. Okay. For mixed income earners, you are employed, at the same time you have a business, then mixed income. This is now, there are other reforms here that you can read it. There are other forms that you can read it, which is also self. This is also self-explanatory. Okay. Now you have estate tax. Before, it's graduated. Okay, 200,000, below 200,000, exempt. If the net estate is 200, below 200,000, that is what you call exempt. So when we say net, it means there is a gross. From the time of the death of the decedent, you are going to it's like you're going to have an inventory of these properties, movable, immovable properties, and per per property you are going to attach the tax declaration, the latest tax declaration there, how much money in the bank, because from the word itself, estate. So in law we call that one, you collate everything. You collate everything. So that is it. So gross estate, net estate is equals to gross minus allowable deductions. Okay. Now, but I mentioned a while ago that this was already simplified, and it's simplified that it is now 6. It is now 6%. Okay. All you have to do is to make an inventory of the properties, personal, real, intangible, like stocks. Then what allowable deductions? And the allowable deductions here, like for example, the family home, it was already increased. The family home was already increased. The standard deduction before was only 1 million. So on the computation of the net estate, you would be able to see here the major changes, that there is an increase of the standard deduction, and there is also an increase on the amount of the family home. Those are what you call allowable deductions. So when we say standard deduction, it means that no questions asked. It means, when I say no questions asked, it means that you don't need any evidence at all. You don't need any evidence at all if there is what you call a standard deduction. Okay. Now, so major changes: before, you're allowed to submit notice of death, and if you cannot submit this notice of death, what will happen is that you will be penalized when you file your estate tax application attached with the extrajudicial partition or extrajudicial settlement of state. They will ask for, BIR will ask 500 pesos for the. So this must be filed before, within 6 months after the death of the. So it's there are major changes now on estate tax. So other changes, you can also read that one. So these changes are no longer applicable now. Okay. So the donor's tax. Okay. The donor's tax before, it was also a sort of what you call graduated. If you take a look at on the left portion, it's graduated. Okay. The first 100,000 exempt, but now it was already increased. If you take a look at the new tax rate now, and how much in excess of 250,000, it's already 6%. Now, before, if you take a look at here, if you donate a property to a stranger, if you donate a property to a stranger before, the tax was 30%. But now it is uniform. Whether or not it is a stranger or it's not a stranger, it is 6%. So this is also, this is also very, very applicable. If you, for example, if you have a lot of properties and you have children, so that these children will not quarrel anymore in the future, you start transferring your properties, the titles in their names, for as long as you are still alive now, provided it does not exceed 250,000 pesos in one. That is in 1 year. Okay, donors tax. Okay, VAT is already 3 million now. That's already VAT. Okay, by the way, I forgot to tell you last time, if you were, last time, I forgot to tell you that in crafting your deed of sale, I mentioned that it must be stated there who will pay for the capital gains tax and the documentary stamp tax. Because as a general rule, the capital gains tax must be paid by the seller because it is presumed that he gained in the transaction. So that 6% capital gains tax will be paid. However, this could be shouldered by the buyer if that would be stated in the deed of sale or deed of absolute sale. Now, the documentary stamp tax, as a general rule, that is actually the obligation of the buyer, because he wants to have the lot, the title transferred in his name. But I want you to be very, very careful when you like, for example, this is very applicable to yourself. If you're going to buy a property, now, if you're going to buy a property, you have to look at the person who is dealing that property, who is selling that property in your favor. Okay, like for example, if the person who is selling the property is a real estate dealer, he buys properties, he sells properties, the probability there is that he could reach the threshold amount of 3 million. So if he could reach the amount of 3 million, then he is liable for VAT. That is 12%. Okay? Why? Because of that. Because he's a real estate person. Now, real estate dealer. If, for example, what you're dealing also with what you call this one, real estate developer. Because the real estate developers also, purchases, farm lots, then or agricultural lots, then converts it to residential lots. These issues. In other words, the issue there is they are also liable for the EVAT, which is 12%. Now, listen to this. Because you were not able to listen to the online lecture of Filipino homes. So what happened? You just sign and sign. It stated there that all taxes, transfer fees, registration fees, and notarial fees shall be shouldered by you or shall be shouldered by the buyer. That is a very, very, you will be placed at a disadvantage on that. Because the property that was sold by the real estate developer, the property that was sold by the real estate dealer was considered as an ordinary asset. So in selling properties, it's either ordinary or capital asset. So when we say capital asset, it is an asset that may or may not be used in the ordinary course of business. When we say ordinary asset, it is used in the ordinary course of business. Look at the developer. When the developer sells properties, it becomes an ordinary transaction. For them, it is an ordinary transaction. So it is an ordinary asset. Like real estate developer, buy and sell, buy and sell. So in other words, that is an ordinary asset. And when it comes to an ordinary asset, and the person that is selling or the company is selling is VAT registered, and you mentioned in the contract that you will pay all the taxes. Sinabi mo all. Then you will shoulder the 12%. Now, BIA rulings here is that, if it is an ordinary asset and it is being sold, like for example, by real estate developer, do you know what the liabilities? 30% corporate income tax, 5% withholding tax, and 12% EVAT. And because of that simple, mistake, okay, and you just sign and sign. You know what happened here. I have clients. They usually give me 1,500 just to show me a contract. Attorney, I'll send you 1,500. Okay, is it safe? Is it advantageous? That's it. Now, you did not attend. You did not listen. You did not watch the online lecture of Filipino Homes on May 11, 2020. Then you did not call. You did not call the lecturer. Okay, that's another chance. Call the lecturer. Send the contract. Let the lecturer read the contract. Okay, just send 1,500. Okay, but you did not do that one. That is your mistake already. Okay, I hope you got it. Okay, you got it. Now, I hope that's it. Okay, I want to emphasize this excise tax on automobiles. That now excise tax on automobiles, if it is hybrid, you still pay it. But if it is fully an electric car, then there is a statement here in the notes that if it is, you would be placed at a great advantage if you buy a fully electric car like Tesla. Okay, why is it that? Of course, this is not. This has a minimal relation in real estate. But why is it that I mentioned here about automobiles? Because if you're a real estate salesperson, real estate broker, my advice to you: between buying a house and buying a car, you buy a car first. Do not buy. Of course, you say security. Okay, let's have, but always remember, especially if you are not married, always remember that you only need 8 square meters in order to sleep. Time will come that you will be able to buy a house, a design of your own. But my advice is you buy a car. You buy a car. Okay. So documentary stamp tax, very, very important, of course, because our government needs to increase the revenues. They need to increase it also. But as a general rule, there is actually a minimal difference when it comes to computation. 1.5% of the contract price or zonal valuation, whichever is higher. And also there is a difference between when these BAR people will compute the documentary stamp tax. They're going to state it itemized. So 15 pesos per one, first 1,000, then another 15 pesos for per 1,000, and a fraction thereof. When you compute, if you are a very technical person, there is actually a minor difference between 1.5% and 15% per 1,000 of the contract price or zonal valuation per square meter, or and a fraction. So there is but it's only it's negligible. In other words, but as general rule, it's 1.5% general. But if you're just now, when you have this one everything, then you have to, like, for example, transfer the title in your name. I want you to set in your minds that what you will be paying is more or less, it's 10% of the 10% of the contract price. Okay, so like for example, if the contract price is 2 million, then you set aside 20,000, because just imagine 6% for capital gains tax, 1.5% for documentary stamp tax. That's already 7.5. Okay, you still go to the assessor's office, you still go to the register of deeds, you still go to the treasurer's office, local treasurer's office, and notarial fee. So you set aside 10%. Okay, that's it. Documentary stamp tax and other taxes. Okay, okay, that is it. That's the summary of the train law. All you have to do is to just browse it, read it, and that's it. Okay. The government is now offering tax amnesty for delinquent taxpayers, and that is Republic Act 11213. Okay, so because of that, the Department of Finance, through Finance Secretary Carlos Dominguez, on April 5, 2019, issued Revenue Regulation number 4, 2019, to implement the provisions of the tax amnesty on delinquencies under the Tax Amnesty Act. This was published on April 9, 2019, and it says in the law that it would take effect 15 days after its publication. So 15 days after April 9 is April 24. So it's supposed to be April. It passed already. But because of this COVID pandemic, okay, it was extended to June 8, 2020, except estate tax. So in other words, when tax amnesty law, there is a general tax amnesty now that includes non-payment of capital gains tax, donors tax, percentage tax, but you can still avail it up to June 8. So if the transaction was done in 2016, 2015, you can still do it now up to June 8, 2020, except for estate tax. Why? Because the law states that the estate tax amnesty can be availed of for 2 years. So they will deal that one later on. In other words, because there's an issue here, because according to the law, it states that it okay, it took effect on April 24, 2019. So if you compute 2 years, it would be April 24, 2021. So, but because of this pandemic also, so the issue here is, will the last 1 year be reckoned from the time of the lifting of this ECQ, or would it be counted record from April 24, 2019? So according to the BI, well, let's just cross that bridge when we get there. Okay. Okay. Now, there was a last slide. Okay. Last word from George Bernard Shaw. There are those that look at things the way they are and ask, why? Some would ask, how were they able to acquire it? Like example, there are those that look at things the way they are and ask why. Like for example, they were able to purchase condominiums, subdivision, units in posh subdivisions, and also nice car. And some people would ask why. Some would even ask, how were they able to acquire it? But I dream, and according to Bernard Shaw, I dream of things that never were, and ask, why not? I can acquire that one. Why not? So in other words, this is a rich imagination. If you want that, you can buy things like, for example, if you want to buy a car, a specific car, you can buy that one. Just follow your dreams. And always remember what George Bernard Shaw said. Why not? Thank you very much. I hope you learned a lot today.
Wow, amazing, attorney. Thank you very much for a very descriptive train law and taxation discussion. A lot of people are so excited, and so many questions. Why do we have to buy car, not yet condo?
Actually, that is that is a preference.
Yeah, preference.
That's a preference, but we had an argument, to be honest. Also, I had an argument before on this with my wife, because we men, we prefer security. We have to secure first our family. That's it. My wife said, we have to buy car first, then a house.
Yeah.
Well, at the end of the day, you lose your arguments with your wife.
Yeah. The wife is always the neck of the man. Okay, so let's proceed. So maybe we have some questions here. I have some questions here, attorney. What about the legitimate salesperson under the broker? What's the employment status? Is employment contract necessary in the case? Yeah.
Yeah. Well, actually, it depends on the agreement between the parties. Like my advice is actually that there is an agreement that you're going to sign, but that is not the usual practice. But my advice is there must be an agreement, even it is not notarized, that in case there is a project selling, you get only this one, you get only
Mission.
this
Yeah.
one. Yes, I think that is. Now, it's not actually that. It depends. If, for example, you are a legitimate salesperson, then there is a realty firm, and you also stay there because you are required to stay there 9 to 6. In other words, you could be considered as an employee of the real estate broker. Now, so, but if you just arrive there, it depends on your time. You arrive there at 10, you arrive at 9, you arrive, then leave at that, then there is no employer-employee relationship.
Yeah.
So it really depends on the facts.
Yes. The most important, you have a contract for your commission, your rate. So at least you will not argue because most of the arguments will really focus on commission. Di ba,
Yeah.
attorney? So next is less than 3 million condo. Bakit po non-BAT ang conditional sale?
Well, actually, that is the reason there is probably they want to evade also taxes there with the
Okay.
BIR.
So evading taxes, is that legal or illegal?
That is that is actually illegal. Anyway, when you purchase, usually when you purchase even in subdivisions, there are two contracts that would be signed, and you include also the special power of attorney. Like
Mhm.
the first one is conditional sale, that would be notarized, but the deed of absolute sale, the deed of sale or deed of absolute sale will not be notarized in the
Okay.
meantime, because you are going to wait until the amount will be fully paid. And
Mhm.
also you don't have a problem anymore if, for example, you have already fully paid it. You can get the title from the bank or from the financing institution, because you have this special power of attorney, and you don't need to look for the seller anymore, because you already prepared the deed of absolute sale and you signed it already with conformity of the surviving spouse, as the case may be.
Okay. There are some instances, attorney, I always encounter a lot of seller. I mean buyer, when they buy a property and they want to resell it. Example, Roland, they buy 1,000 square meter. Then they execute a deed of sale, but they don't go to BIR to transfer it to their name, and they will resell it to another person without escaping all the taxes. What can you say about that?
Well, for me, that is actually a strategy. That is actually a strategy. But the only problem is actually my experience that is that those who are in the government are not also that aware of the strategy. Why? Because supposed to be, if you are the notary public, you are going to give a copy to the BIR,
Okay.
okay? A copy of that deed of sale,
Okay.
okay? So, because for a problem also, the notary public did not give also a copy to the BIR. So the BIR personnel do not know about its existence.
Mm,
Okay. Well, I can say that that is a strategy of a person, so that actually they could evade it. Yeah, they could evade the capital gains tax and the documentary stamp tax, because if the deed of sale was already sent to the BIR, then they could not evade it.
okay. So at least that's their way of escaping some taxes.
Yeah,
Yeah.
yeah.
So anyway, attorney, there's a question here. Do we have some law, or do we have a law that provides consideration in line with taxation for the senior citizen? Do they have discounts?
When it comes to the sale of properties, it is fixed. It is
Fixed.
60% or something.
So when you go to BIR, there's no senior citizen there. There's no line.
It's only a line there for
Yeah,
seniors.
this is very interesting because we might encounter as an agent na, oh, I'm a senior citizen and my buyer, I'm 60 years old. Do you have discount? And some agents are so ignorant, they don't know how to answer. They call their broker. At least now, with everybody who are here, so remember, when we talk about BIR, it's fixed, no
Yeah,
negotiation.
yeah, it's fixed.
Yeah.
And also, I think it's a matter of uh, negotiating it with the owner of the property. Like, for example, what is the purpose of buying this house and lot? Okay,
Mm-hmm.
what is the status of, like, this couple? They don't have kids.
Uh-huh.
Okay, they don't have kids, and they are already 72 years old.
Okay.
Like, So you can talk to the seller of the property. I think it's better to give them a discount there. It's because
Mm,
they could only enjoy the property for a couple of years.
couple years, yeah.
Yeah. But if, for example, so it would really depend on how you talk to the seller of the. But if the couple who would reside in the the
House,
unit would be,
yeah.
like, for example, 40 years old, and they have like, for example, two kids. So in other words, they could still transfer it transfer it to the. So I think they could negotiate when it comes to the
Yeah.
price.
So it will be the agent's discretion to how to be a good seller, I mean agent. So they can
Yeah,
ask discount to the seller na, ma'am, consider my buyer, she's already 72 years old. Can we give him a lower price? That's a good idea.
yeah.
So I know a lot of people are learning here. So next is, how about the joint bank account? When one passes away, how much will be the declared estate tax? And does the surviving spouse can still access the account?
Okay, okay. What's the joint account? Is the joint account of the husband and the
Yeah,
wife?
they have a bank account, and husband died. Will the wife can still access the account?
Okay. For actually, from the moment of the death of the decedent, no no release of funds should be allowed. No withdrawal of funds should be allowed, because actually, when you open, number one, when I say when you open the joint account, it must there must there's a statement there that the two of you should sign.
Okay.
And the only way there to get the money is that, usually, and that happens, is that the wife knows how to sign to imitate the signature of the husband. So the bank will really release the but that is, that is very risky on the part of the wife
Wife,
doing that,
yeah. Because
because from the way so the computation, the gross estate will include from the moment of the death, so it should be freeze. Even if, for example, you are a good, you have a connection with the manager of the bank. The manager of the bank knows that the husband already died. The manager of the bank could be terminated from his job. That is, for me, if
so
it's.
the consequences is the biggest problem there.
Yeah, yeah, yeah.
But attorney, what if the bank account is and or, not only and or?
Okay, so that could
Different.
be
That's different.
that's different.
Okay.
That's different.
So again, another question I have in mind. Number one, if I have a property and I want to save taxes, and I have a lot, 50 square meter, I have a house, 100 square meter. Um, I want a separate tax. I mean, I want a separate deed of sale of my lot, and I want a separate deed of sale of my house. Is that allowed?
Yeah, actually,
Really?
Sir Ton, this is an old decision of the Supreme Court.
Ah,
Uh,
okay.
Old decision of the Supreme Court. The house, Boston, could even be considered as a personal property. Just imagine that.
Mm,
It could be considered as a personal property. However, that agreement must only be applicable between the parties.
correct.
In other words, so if, for example, you enter into a contract,
Buy and sell. Buy and
then
sell. Buy and
okay,
sell. Yeah.
I'll buy and sell.
So you're the seller. You're the buyer. I'm the seller.
Okay, so the house could be considered as, between between the two of us only, as a movable property, but that is only between the two of us.
Okay.
So in other words, if if, for example, there would be the house and lot would be sold, this what I call a sale, what you call this one, a double sale, then that is the risk on your part. It's
Yes, correct.
because you treated that one as a personal property.
I'm talking on this on the BAT issue. Okay. So example, my house is 4 million. I want to price my lot 2 million. I want to price my house 2 million. So I will escape from But right? So will that be allowable practice?
It's not actually. You have a problem there when you go to the BIR
Okay.
because the when it comes to the BIR, you are required to submit a tax declaration on the lot and the tax declaration on the house. So,
Mm.
in other words, you cannot escape that one. Of course, it would be considered by the BIR. So
Because
that
the BIR will ask, where is this house located, right? So, anyway, so you will still connect your lot to that house. So they will
Mm,
consider it as one sale.
yeah.
Okay, now I understand. Then another question: how many properties sold by an individual to be considered as habitual engaged in real estate selling? Will the tax increase from CGT to BAT? Habitual engagement.
Okay. So
So how
actually,
many properties, attorney?
as far as I know, for as long as it does not exceed, it's more than the most important. It's more than one. It's more than one.
More than
So
one.
and actually, this habituality was actually explained, I think, by Engineer Eleanor already.
Okay. Anyway, this is very very common. Most of the seller, they sell it at 10 million, or assuming they sell it at 5 million. Then the buyer said to the seller, "Can we undervalue this for tax purposes? 3 million. This is both of us." Okay. So we create one contract which is 3 million instead of 5 million. Even they will be caught in BIR for the which is have high whichever is higher, was this threshold, correct, attorney? So is that a legal practice, or is it allowable practice if we if the buyer will say, I will undervalue on our this I mean of our agreed price? Is that allowed?
Actually, that is allowed. The
Okay.
only problem there is a saying that goes, "What is legal is not necessarily moral." So there's there is actually an issue there.
Okay.
It is because I think I think it's Mom Eleanor discussed the code of ethics, that it is unethical on the part of a practitioner to to reduce,
To encourage.
discourage. Yes.
Yeah.
However, of course, in reality, that is what is really happening. That is what is really happening. So for me, actually, although it is not encouraged, but that because that is happening. The most important for me, the most important is the real estate broker must not participate, if possible, must not participate in that,
Transaction.
in that transaction. Okay, there is a sale, but do not affix your
Yeah.
signature there as one of the witnesses. For me, I think that is my guide,
Because because the job of the agent and broker is just match, not negotiate, right?
Yeah.
It is the buyer that negotiate to the seller, and don't even encourage to give bad advice to your buyers and sellers. Okay. That's good idea, attorney. So next, another question, attorney. Can you just sell a lot and not the house, or vice versa?
It's the same. I think it's the same with your with your question a while ago.
Okay.
Because I mentioned that the house can even be the subject of a chattel mortgage. So when we say chattel, it is personal property.
Mm-hmm.
That's already a decision of the Supreme Court.
Okay. Interesting. Attorney, what about the conjugal property? The husband died 25 years ago. The wife is paying yearly tax. The title is still named to both until now. So can their children sell the property?
Yes. Okay. The most important there, because that's what I also mentioned last Friday. If somebody died, okay, if somebody died, then there must be a extrajudicial partition first. Okay, if there is now a willing buyer, ready and willing buyer, then extrajudicial partition with sale, that would be executed now. So if there are children and all of them survived, all
Yeah,
of them must
was signed.
sign. Yeah.
Mm, okay, that's good. Okay. So we have another question from Melby Sadang. Okay. Foreigner can buy a house. Lot can be bought by the Filipina. What's your say about that?
Yes, yes. Okay, in the Philippines, you cannot, if you are a foreigner, you are not allowed to own a lot, but you are allowed to own a house. Okay, so like example, okay, uh, just imagine condominiums. Condominiums. This is already a ruling of the Securities and Exchange Commission. If there is a foreign, real estate developer in the Philippines, and that foreign developer will lease a lot in Cebu, assuming in Cebu, it's like, for example, 3 hectares, and the developer will construct condominium units there. Boston,
Yeah, boss. Yeah.
all the units of that
Condo.
condo can be sold to foreigners if the lot is leased.
Okay. So if it's leased, meaning it's absolute.
It's if
The
it's leased,
the
it is,
building, the building,
yes,
they
if it's
can
absolute.
absolutely
Yeah,
sell it. Oh.
yeah. That's already
So,
a ruling of the Securities and
but the
Exchange
lot
Commission.
will still be owned by Filipino, and I don't care. I'll sell the whole building, 200
Yeah,
units.
yeah.
But
So
what I mean regarding the issue on 60/40 ruling on the ownership of the whole corporation, how does it create conflict there?
actually, there is no conflict there.
If
There
it
is
is
no,
leased, if it is leased,
because in the condominium corporation,
okay,
the sharing there is 60/40. So
okay,
there are directors that could sit, as foreign directors could sit, but only up to 40%.
okay,
60 must be owned by Filipinos, and that is
Filipinos.
why the units there, only 40% could be sold. Uh,
Mm.
there.
So the
Okay.
40%. But we have actually we have so many developers here. They exceeded 40%
Oh,
ownership of the foreigners, and what they did is they created the extra more than 40% to lease, and that will escape them from ownership. I mean, from not being an owner. So it's a new strategy used by some developers who exceeded the 40% ruling of the SEC.
okay, okay. So probably I cannot blame there. I cannot say anything about it, because probably, they also have lawyers, so they
Yeah,
probably they went
they have
to the
their
security.
argument with that.
Yes, 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 yes. So
I
okay.
talked to I talked to the developer, and I saw some issues in some projects in not in Cebu but in Manila, because since most of the condos there are very expensive, so no Filipino can buy, so Chinese, American, so they sold the more than the what's this the threshold of 40%. They sold it as leased unit. So, and that is allowable because a foreigner can lease a lot, can lease
Yes.
a property without owning it, and it's allowed. So that's their arguments there.
Okay.
Anyway, Attorney, I know this will be a very nice discussion. Both of us,
Yeah.
I'm also learning. All of us are learning from you, from your expertise. So thank you very much. God bless you, Attorney.